Federal mandatory minimum drug sentences provide that if someone is convicted of selling or conspiring to sell over a certain quantity of a particular drug, a judge must sentence the offender to a certain minimum sentence, which can, depending on the offense, range from 5 years to up to life imprisonment. Prosecutors will often charge and prosecute the most serious offense they can prove. This policy of charging high can be traced back to 1989 during the first Bush administration. This policy was eased under the Clinton administration, revived under the second Bush administration, and relaxed again during the Obama administration. Prosecutors generally want to start off at the highest point that can be proven at trial. This way, they have leverage during plea negotiations and can secure cooperation to get bigger fish, particularly in the drug trade. Criminal proceedings are adversarial. An accused individual has a constitutional right to an attorney. That attorney will try to do what is in the best interest of their client. After their client has been charged with a crime, that usually means they will seek to secure a dismissal of the charges or obtain a finding of not guilty for their client. At the very least, they will seek to have their client plead to lesser charges, which often provides for a more lenient sentence. That is why prosecutors will generally charge high. They will have a higher starting point for plea negotiations should they materialize. Attorney General Sessions stated, quote, "We are returning to the enforcement of the law as passed by Congress, plain and simple. If you are a drug trafficker, we will not look the other way." Sessions singled out that Congress has given him the authority to use mandatory minimum sentences in charging high-level drug traffickers, which demonstrates that he is enforcing the law. The balancing act will be making sure that the new policy is indeed aimed at such individuals and not against lower-level players who are only marginally involved in large-scale drug conspiracies. These include low-level runners who are merely involved in the trade because they have an addiction problem. Under current federal law, an offender who has been convicted of an offense that carries a mandatory minimum sentence can escape receiving a mandatory sentence if they provide substantial assistance to government officials, which would allow the government to prosecute others who are engaging in serious criminal conduct, or qualifying under the safety valve, which is designed to provide relief to those who are lower-level offenders with little to no prior criminal record. However, an issue is that the safety valve is rather narrow and applies only in a few circumstances. Additionally, these lower-level players are often never in a position to provide valuable information to the government because they are too low on the totem pole to have any useful information. It is worth noting that Congress attempted to expand the safety valve last year. This would have brought the federal safety valve more in line with the ALEC Model Justice Safety Valve Act. Many Republicans and Democrats were in support of the expansion. However, due to a number of factors, the expansion was not passed. In essence, expanding the safety valve could have prevented the concerns that many have about the use of mandatory minimums. Ultimately, if the Sessions Department of Justice implements this policy on mandatory minimums to go after individuals who represent the greatest threat to public safety and not against nonviolent, low-level offenders who simply made a mistake and do not merit harsh sentences, the public will be safer. And for additional information on mandatory minimums, please go to the ALEC website at www.alec.org.